All right, welcome everyone. Welcome to the the Moorish Investigative Research Committee. Welcome. This is June 29th, 2024. This is the second committee meeting. All right, sponsored by the Moorish Union of Sovereign Tribes and the Moroccan Post School of Government and International Law. Moroccan Post School of Government and International Law. So we have a review that's on the screen, right? This is a review. The first session, which was 3 weeks ago, was on the conclusion of law and finding of facts. All right, so we're going to, King, you take it away.
Okay. Hold on, if you can scroll up so I can see some of the best evidence standards so we can get into the review. So, okay, hold on, you went too far. Stop right there, right there. So, when dealing with evidence, when we're trying to present a case, you want to use the best evidence possible. You have what they call primary and secondary forms of evidence. So, what is the best evidence standard? And the question is answered: the best evidence standards require the original piece of evidence, particularly documents, must be produced in the court to prove a case or other material. Contracts is one that you want the original contract. You want the original power of attorney, the original whatever, so that you can show the authenticity of the original agreement or assignment, in which you can verify and show your legal understanding of what the contract emphasized, so that you can make sure that you were within the context and the boundaries of the contract. The principle ensures the accuracy and reliability of the evidence. So, for example, like sometimes a lot of people will, under a contract, they might have the company, like for example, you sign get a social security card. They will have the original documents that you signed, and they're required to keep those for so many years, right? And then people can renew and update these contracts and show where they have been amended and all of that, right? Hold on one second. Hey, I gotta call you back, babe.
Okay.
Okay.
All right.
So what I'm presenting to you is, when we're dealing with case law and we're dealing with your case, you must understand the best evidence standard, right? The primary sources of evidence. Now, what happens when evidence is lost, damaged, or destroyed? Let's say your house catch on fire, right? If you can remember, you can do an affidavit based on the content in the contract as a secondary, or you can have someone who has a copy of that, of the original contract, that may be used in a secondary, and then they can attest that this was a copy of the original agreement. You a supporting affidavit to show that this evidence is a part of the original, this is a copy of the original agreement. So these are things that you can do, right? Now, what is a finding of facts? Question: what is a finding of fact in legal proceedings? A finding of fact is determined, made by a judge or a jury regarding the facts of the case. These findings are based on the evidence presented during trial and are used to establish what actually happened. So, like I said before, you have your attorney at law and your attorney in fact. I want y'all to understand, when using the facts, right, you want the original pieces, right? So when you start presenting contracts and other things, right? Now you can show these things in its original context and that these are supporting documents. And I'm gonna give you an example of what Moors do. Moors will say, I'm not a part of the jurisdiction, but they have a social security card. They have a driver's license. They have all of these things, right? All these documents in their possession. None of them will have where they rescinded the Social Security, right, to the Social Security Administration, where now they can show with the affidavit that they sent it, time and date, who they sent it to, and that they canceled their relationship under original agreement. They can rescind their driver's license and show where they sent it back to the BMV and the address and the affidavit and all the other supporting material that support that in the original action. So when they go to court, they can say, hey, I'm not doing this and I'm not doing that because I have rescinded these things. And here's the proof. Here's the affidavit that supported, right? Here's a complaint or a motion that I filed to show that I have rescinded these things in accordance to the law, that I have rescinded these documents under whatever statute or code. And then you have it supported by affidavit with the exhibit showing that you rescinded these instruments, showing that you mailed it off and showing what you did. You filled out the copy and that you mailed it to that particular institution. These are things a lot of Moors don't understand, the evidence standard of practice dealing with the findings of facts and conclusion of law. Can we continue? So, what is evidence? What determines evidence? Question. What determines whether something is considered evidence in a legal proceeding? Evidence is a determination by its relevant material and admissibility. It must be relevant to the case. It must be material to facts in dispute. It must meet legal standard to be admissible, such as being obtained legally and being reliable. And what do they mean by being obtained legally? So you will have officers that will do an illegal search and seizure. Based on that illegal search and seizure, they can't present evidence because what they did was illegal, right? So we must understand that. We got to object to that because a lot of times they will present evidence and we don't know the legal nature of it, and it'll pass through and it'll be admissible when it should have been deemed inadmissible on its face in the court of law. Another thing that you need to understand is obtaining legal things. Let's say someone is a minor and you're required to be their parents to be there, or certain things. Those are something that can be obtained illegally, right? Something that somebody obtained a statement without reading you your Miranda rights. They're not giving you a right to remain silent. They may have did something to you. They might have abused you. Officers have sometimes beat you to make a confession, right? Could you go up just a little bit of Kono so I can still be in that question? Now go up the opposite. Okay, evidence right there. So we have to understand what is admissible evidence. I want y'all to know what is admissible evidence. Something that is relevant to the case, that also it was obtained legally. If something is done illegally, then it would not be considered evidence if it was obtained in a legal form against a person will or something like that. So I want y'all to understand what is evidence. Okay. It says, what is a fact? What is considered a fact in a legal proceeding? A fact is a legal proceeding is an objective reality or event is either admitted by the parties or proven by evidence. Fact distinguished from opinion and belief or interpretation. So I need y'all to understand there's a difference between truth and fact. I need y'all to understand your truth don't have to be my truth. Me and you can see something and you can have come to a different conclusion than I have. But once a fact is determined, it's the truth.
That's the truth. That's it.
So we need to understand the difference between truth and facts. According to the rules of evidence, it's based in factuality, not truth. Something only becomes true in the court of law once it meets the evidentiary standards of what a fact is.
Court is not about hearsay, it's about what you can prove.
So a lot of people, when they go to court, that Moors are put in an affidavit of truth. What do that mean? So when we're dealing with facts, I want you to understand facts is based in scientific, right? It's be something scientific, but it's supported by an actual occurrence.
Right.
An actual event, occurrence, an actual situation.
Right.
Truth is objective. Truth can sometimes be obscured because me and you can, based on our perception, can come up with two different truths. What's true to me don't have to be true to you. Some people believe in Jesus. Some people believe that Jesus is not the Messiah. Some people believe what they want to believe about different things. But who is true? Is that truth? Is there any facts that support these things? So we have to understand what the truth is versus what a fact is, so we stay relevant into the court of law based on these procedures and standards of practice. And I see this happen too many times when Moors go to court. They don't understand the difference between, so they don't know how to make points of reference in accordance to the rules of evidence. So what is a conclusion of law? What is a conclusion of law in legal proceedings? A conclusion of law is a decision made by a judge on the...
King, just 1 minute. Go back to, I want you to spend a little more time on, you made a comment. Let me put my video on because I'm out and about, y'all. You made a comment about having the knowledge of tying evidence with procedures.
Right.
Yeah, continue, spend some more time on explaining that.
Okay, so
give some example, yes.
So when you look at, there are the rules of evidence. They have a procedural outline, how evidence can be presented, how evidence can be used. They have a standard of what is evidence and how to present evidence. If you're not following those rules and you don't understand those rules, you can have good evidence. But if you're not what they call procedurally sound with incorporating these rules the right way, your evidence can be disqualified. So you have to understand these rules. These rules set up a standard of practice. These rules set up how you go about doing everything. And if you're not coherent with the rules, then you're not playing by the rules, and the rules will not support you, in which the court cannot support what you're doing. You can't just go do anything you feel like. That's why they have rules. I hope that makes sense to everyone.
Does anyone have any questions before King goes on? Before King continues, does anyone have any questions or comments? Questions or comments?
Yeah, what is the difference between a rule and a guideline?
A rule and a guideline. Okay, under operation of law, right? A rule is it's permanent. It can't be manipulated. You can't change the rule. It's set in stone. A guideline is something to guide you. It's not fixed. It's just to give you something, a point of reference, something to give you direction. Do that
All right,
make
so
sense?
one is fixed. So that's the distinction. The distinction is that a rule is fixed. So this is a key distinction. A rule is fixed, guideline non-fixed. Because they both guide. They both do guiding. They both do guiding. So that's the commonality. They both do guiding. So what's the distinction? So rule is fixed, guideline is not fixed. So we got to point out there's the similarities and there are distinctions. So the major distinction is fixed and non-fixed. All right, do we have that?
And another distinction I made to make clear,
Yes.
when you
Yes.
violate the rules, rules come with sanctions.
All right,
Guidelines
put that down.
doesn't.
Another distinction, rules come with sanctions upon violation. We all have our notebooks. I'm assuming. Yes, I am. I'm assuming. It's right for me to assume. It's right for me to assume that we have our notebooks. That means meaning that we're serious, we're focused. So we all have our notebooks and pens out, meaning that we have done our job. We have spent time in preparing the lesson. We're here for you today. We've done our job. So we all have our pens and notebooks out. So I'm assuming that, yes.
So when you break rules in law and you go into the court, these are procedural violations. You can get sanctioned. If you bring in a case, your case can be thrown out. A guideline is just giving you a point of reference for something to follow. It don't have sanctions. It's not fixed. It's not set in stone. It's not permanent. But rules are permanent. It's fixed. And they have violations when there's sanctions when you violate these rules. So you must understand this in the court of law when you're dealing with these things so that you can be on point when litigating your points of reference and following and adhering to the rules.
So are you saying that rules are rules based on factual interpretations and guidelines aren't?
Say that again?
Are you saying rules are based on factual interpretations and guidelines aren't? Because if one's fixed and one's not fixed, then is there like a governing body that be able to determine what's a rule?
Yeah, the Supreme Court. So let me answer that. The Supreme Court create all the rules. All your rules of procedures, all your rules of evidence, all your different forms of rules. The rules govern the practice of law.
Mhm.
You cannot go outside of these rules.
Okay.
Now, when somebody give you a guideline, they give you a sheet, a guidance sheet, they say, well, you can reference this to help you move along with your process. But it's not set in stone. It's not governed by the Supreme Court. But these rules are governed. They look, the Supreme Court look at these rules and see that did you prescribe to the rule?
Mhm.
And did you violate the rule? And that's what they're going to check off. And if the other party said you violated these rules and the Supreme Court agreed, then you can be hit with sanctions. Your case can be dismissed with prejudice or what other sanctions that could be applicable to your violations. Do that make sense?
All right.
I'm saying, do it make sense?
I mean, I'll accept it for now, but you know, I just got to look further more into because I'm reading a lot of stuff about evidence and all that stuff now. So I have to accept it right now until I get more knowledgeable.
Okay.
That what you just said makes sense to me from the aspect of understanding and knowing that the Supreme Court makes sure that any quote unquote rules that have been set do not violate the treaties from that aspect. However, when you're inside the U.S., it might show itself from a different aspect because it's not necessarily based. They don't operate from that same rule. They don't have to. So that does make sense. But if a lot of people are not necessarily dealing with the international point of view, it's not going to come across the same way because we watched them violate it the whole way. So I think one of the things of us being on this committee is to understanding the swapping between international law and being inside the U.S. We got to get that. So when Brother King is going over these rules, we're talking about the proper way that it's supposed to be ran, not the way that they do it. Case in point, when he made a comment about the evidence and the officer. Well, the officer can't necessarily submit evidence. That's a conflict of interest. You can't get into court without him. So you should never have an issue with the officer. He's supposed to be there between the affiant and the respondent, if one of them called, if that makes sense. So we got to put it in its proper place when he's talking. That's just how I'm hearing. Go ahead.
You have to understand the officer's relationship, his status. He's a witness. He don't argue the law. That's what the prosecutor's there for. You have a license. You have to be assigned as a prosecutor and have a license to practice for the state. The officer is nothing more than a witness. He's presenting the facts. The prosecutor is arguing the law. And without the officer, the prosecutor have no facts to stand on in which the law has to be supported by facts. I beat cases all the time. So, what is your name? Kamat El? How they?
Yes. That's serious. It's me, Ross Serious. That's my actual appellation, Timothy. What's going on, brother?
What's going on, brother? You have a question?
Yes. As far as guidelines and rules, would the guidelines be considered synonymous with protocol? Their protocol?
No, not necessarily.
Okay.
A protocol could be something that can be introduced as a rule or a procedure sometimes. A protocol is something that it depends on the construction of what is done. So I can have a protocol, right? But it don't necessarily mean that if I didn't follow the protocol, what if I meet the same outcome by completion or making something satisfactory? Would I be sanctioned, right? So it depends on the language and the duty under the contract that you're under associated with a protocol. Because a protocol can be what you have to check out, all the things that you must perform in order to do a particular task. So it depends on the construction. But when we're talking about rules as it relates to the court, these are not protocols, these are rules. And you must follow the rules. You must adhere to the rules. And if you understand how the rules supposed to be met and followed to the T, because I have beat many cases when prosecutorial misconduct by not adhering to the rules. And the court has agreed with me that the prosecutor did not adhere to the rules and violated your rights.
Appreciate that.
So we must understand this to the letter. Okay, go ahead, brother.
Yeah, Brother Kono. So are the procedures
It's
made,
Brother King. It's Brother King.
Brother Kang, I'm sorry. I'm
Yes.
sorry. Is the procedures made through prerequisites?
They are prerequisites.
They are prerequisites. Okay.
They are prerequisites. They must be followed.
Okay. Okay.
If you break the rules, there are sanctions.
Okay. I got you. Gratitude.
Okay. So let's go on to what is a fact. What is considered a fact in a legal proceeding? A fact is a legal proceeding is an objective reality or event that is either admitted by the parties or proven by evidence. Facts are distinguished from opinions, belief, and interpretation. So,
in litigation class right now.
so when you understand what is a fact, be able to present facts in your case, right?
I know about
This is how you win.
Put your mute your
case.
devices. Mute your devices, please.
to litigate by ourselves. We gotta learn how to do that.
Mute your devices.
That case would have
Mute
been.
your device. What do we?
Kono, can you mute people's device? Okay. So you have to understand the difference between, must understand the difference between truth and fact, and you must understand what is evidence, right? So is hearsay considered evidence? So a lot of us will rely on hearsay evidence. What do you mean, Keng El Bey? We're hearing something that a Moor has said and put it into an affidavit, and it has no basis or no fact. It hasn't been proven in law or otherwise. It's not in the treaty. It has no bearing. So a lot of times we will create something, put it in an affidavit, and presume that it's factual when it's not. I see Moors have done this a lot, put in the affidavit, and then they will use an affidavit instead of a motion. They say, well, I'm not giving the court jurisdiction. They already got jurisdiction because they presume jurisdiction. So a lot of Moors will say, I got diplomatic immunity, but they have no supporting evidence from any other country or consult that is recognized under treaty that gave them these supporting documents that they can be verified and reliable under oath. So I hear these common mistakes. Just because you said something doesn't make it true. Just because you said something or heard some other Moor say it doesn't make it a fact. We must understand how to present these things and articulate it enough to ensure the credibility of our evidence, to assure a victory when we presenting these facts onto the court, so that now we'll know how to support our claims with reliable resources. It says, what is a conclusion of law? What is a conclusion of law? And the answer is, a conclusion of law is a decision made by a judge based on the application of a legal principle to the findings of fact. I'm gonna read this again. A conclusion of law is a decision made by a judge based on the application of legal principles to the findings of facts. The facts come first. The application of law is supported by the facts. With no facts, no law can be applied. It determines the legal consequence and outcome of the case. So I need you to understand the difference between findings of facts and conclusions of law. So you have the ability. Okay, go ahead.
So if we get signatures.
If we get what?
Signatures.
Signatures.
Yes, to the ICCJ that we've been, or we make about a claim, are they just going to go on the majority of the signatures, or do we have to also bring proof of the claims?
You got to bring proof.
So sometimes you're saying it's not always the majority that rules.
No, you got to have proof.
Okay.
I can get 100 people to sign something,
right,
that's based in a lie.
What about misinterpretation?
Misinterpretation of what? When you say misinterpretation, we got to put that in proper context. What do misinterpretation mean?
Well,
what do you mean by misinterpretation?
Well, because what I'm saying is sometimes somebody can make a claim and they'll just bring the claim through the experience of that particular claim, through how they experienced it, and somebody else, because people live in different realities. Everybody's have just what you said earlier. Everybody have different realities, and sometimes a lot of these people who sit on these Supreme Court boards, they don't share some of the same realities that they make rulings on or opinions on.
Well, you got to understand.
Okay.
So an application of law, right?
Mm-hmm.
So I'm very good at child support, right? So I'm gonna just throw one out there. Let's say you want your child support reduced, right?
Mm-hmm.
You're going to go to a particular code, right? And under that language, under its interpretation, is going to tell you what qualifies for you to get a reduction in child support, right?
Mm-hmm.
Based on that criteria of that statute, that language, it's called substantive language that is written. Based within that language, I have to do what? Meet the criteria under the application in which I'm identifying this, I have to meet the elements of that statute to get what? A reduction in child support. So I'm coming with an application, right? That I'm going to meet the standard of operation within that language, right? To prove, right, and support my findings so the court can make a conclusion in law to support what I presented to the court. Do that make sense to everyone?
Yeah, but I noticed that you said in law. So what I'm saying is, I know you have general circumstances, and then you have legal circumstances, right?
When you say
And dealing with language.
So if you know the difference between law and legal,
Right, that's what I'm saying. Yeah.
law is something fixed and permanent, and is customary to a particular nation, group of individuals, etc. Legal is a proposition or a condition of contract, which then can become a legal argument and is lawful, right? Because now the two parties have signed a contract, making it a permanent relationship until the discharging of that contract, right? That's how this stuff works. It becomes legally binding on both parties because it's a condition of contract. But what if you have a law within that nation that says that a foreigner cannot obtain permanent rights in land? And you create a contract that go against that law. That contract becomes void, ab initio on its face, because the law said you can't give land to a foreigner under that law. Because the law is decided based on like a constitution in a sense. It's because the people came together and formed these laws, right? So we have to understand these principles so that we can ensure what we're trying to do in the legal arena, so that we don't get displaced and get off track.
Now, when you say the people got together and formed these laws, wouldn't that be more of a republic than a democracy?
No, he's
Would it be
talking a
more-
principle. He's talking a universal principle.
Right.
That's all right. Let's not worry about the Europeans. Let's not talk about the Europeans right now, because the Europeans learn from us. So let's be clear. Europeans learn from us. So he's talking about a principle. All right. You have five. We're talking political science now. Talking political science. There's 5 major political systems in the world. There's 5 majors. Write this down. 5 major political systems in the world. It's not law school. This is political science. Ecclesiastical / religious. Common law. A mixture of common and civil law. So you have civil law. So you have ecclesiastical / religious, common law, civil law, third one. Fourth one, a mixture of common and civil law.
What was the third one?
The third one is civil law.
Civil, okay.
Civil law is the third one. The fourth one is a mixture of common and civil law.
What would
And
that be called?
I just said it. A mixture. I just said it. A mixture of common and civil law. That's what it's called.
Okay.
I just said it. A mixture of common. Let's write it down. A mixture of common and civil law.
Okay, mixture.
Yes. And the fifth one, I'll get back to you. This is for everybody. It's not just for Herr Bill.
I understand. I didn't mean it like that.
Right. So this, no. I'm saying this is political science.
Okay.
All right. So when you're talking about a principle of republic, You have let's start with ecclesiastical, because the republic is not ancient. Ecclesiastical is ancient. So
So
the
that's only
principle of
4.
ecclesiastical is the seer and seership principle. The seer and seership principle. The galactic cross. The galactic cross is the Egyptian statue with the Black Panther. Black Panther arm crosses his arms. The Egyptian statues crosses their arms. That is symbolic of the galactic cross. They took this from us. That's divine law. You have the crescent. You have what they call them, with called a Masonic symbol. The crescent, not crescent, compass and square and the G in the middle. The compass and square and the G in the middle. The G geometry is the blueprint to unlock the secrets on the unseen world. This is all connected. Connect that to the compass, square, and the G in the middle. That's ecclesiastical. All right? It's all tied. It's the unseen world. All right? This is ancient. This is ancient. All right? So no church practices ecclesiastical. Why? Let me explain. No church that has a 501c3. No church. That's not ecclesiastical. A seer doesn't answer to no king. A seer doesn't answer to a president. A seer doesn't answer to a prime minister. A seer is not licensed, registered, answers to no president, no king, no prime minister, no emperor. A seer doesn't answer to that.
Oh.
I'm talking about ecclesiastical. That's not ecclesiastical. No 501c3, that's not ecclesiastical.
Right.
I'm talking about in its original application.
Right.
So when you're talking republic, res publica. Res publica. Res means affairs, R-E-S, affairs, matters of publica, people. All right? The people, the phrase, the people, not the people in the park. The people used in a political sense means the repository of the collective sovereignty of the people vested in a constitution. The people used in the political sense, the repository of the collective sovereignty of the people vested in a constitution. I'm talking political science. So I'm gonna come political science. We're gonna come law. This is political science. All right, I yield.
Gratitude, brother Abdullah.
So as we understand how to utilize these applications of law within the venue, right? Because you're going into a particular venue based on your status. They're recognizing you either as a member in which they determine that you are a citizen, a citizen, or some type of status in which they can recognize under this political assignment. So you must understand this is very crucial to your development in political science, so that you will understand that you have the proper legal tools and ability of discernment when you go into these courts. When you don't have it, you are all over the place. You're reaching and you're drawing straws, and you don't know where you need to be. So now your case and your argument looks ridiculous. The court will say that you're rambling, that this is immaterial. You don't have any legal standing. if you don't get the basics. And we must have these basics, or you're not going to be able to deal with the court appropriately and proper. You must think proper. That's one of the things that is an assignment when you go into court. You must think proper. So let's go on. How witnesses turn into evidence. How does witnessing turn into evidence in a legal proceeding? Witnessing turn into evidence through testimony given under oath in a court. The witness provide first-hand account of what they saw, heard, or experienced, which is then subjected to cross-examination and scrutiny. So you must understand, when you subpoena somebody to court and they testify, another form of testifying is affidavit. So a lot of us as Moors misconstrue an affidavit. They say, well, I put in an affidavit. What is the affidavit supporting? What application of law? You want the court to recognize your affidavit so that they can make a conclusion, because an affidavit should support the facts in which the court can make a conclusion of law. What you was about to say something, Abdullah?
Yes, King, this is good in that you're also addressing misconceptions that we conscious Moors have been presented. So that's very important. Those who on this committee have heard what you've said. So I'm glad that you are addressing misconceptions. We're also you're doing a great job and thoroughly answering our questions. This is like I said before, we're slow walking this. There's no need to give your assignments to do anything, because if you don't have these fundamentals down, so we got to slow walk this. As I said before, it's rightfully for me to assume y'all have a pen and paper, your notebook, not no paper, my bad. 86 that, not a paper. A notebook designated for this, not paper, a notebook. We're doing our job. We are prepared. We put time in preparing for today. We are serious. We're showing by our actions. We are serious. All right, continue, King.
So the misconceptions that we have been presented with and that we use today have allowed the court to trample over us, to allow them to trample over us, and a lot of us are being abused due to this misunderstanding of how to present our cases, on how to understand the application of law, evidence, and these rules. This have been very abusive and abrasive to our community because we lack this understanding. Okay, Kuno, could you go down to the next page? How can affidavits be used as evidence? So, like I said, affidavits is a sworn statement by a notary public. And I want you to understand the power of a notary. A notary is a state official. It's a public office. And the notary, by that public office, is witnessing a transaction in which they're verifying that they witnessed. This is very powerful because now it gives that affidavit support if you know how to properly use the affidavit in support of what you're doing. if you don't know what to do with an affidavit, because I see Moorish, they say we in the country of a maxim, and they say a bunch of stuff and get it notarized, and it's based on fallacies and a lot of different things that's unsupportive. And what will happen is that affidavit it has no bearing. And the affidavit must comply with the rules of admissibility to be accepted as evidence. So we have to understand these things, right? We must understand how this stuff can really be utilized and how to present our case and understand how to use these instruments like an affidavit. I use affidavits in support of what I argue on my application to show and prove the court that I have applied with the application, and here is the findings that the court can rely on, and here is the evidence, also known as exhibits, that support what I've done. And it's based in truth, in good faith.
Question.
Go ahead.
So you're not saying that if you're saying that if we put a maxim on an affidavit, we have to also put evidential facts on how we came up with this once term a maxim on that affidavit, so it can be utilized and read properly to the justice.
Yes, if it's in a contract, if it's in a treaty, right, that you can support. If you in a, if, let's say you got the diplomatic immunity, and in the contract, in the diplomatic immunity, in your status, it under your contract or whatever in the treaty, it states a maxim. You would use that as an exhibit, but it must be some type of material fact that is in alignment with the case.
Duly noted.
Show and prove. But if you can't do that, right, you don't have no standing.
Yes.
This is why when I go to court, this is why people ask me, how did you know what to do, Keng El Bey? How did you win my case? How did you know? Because I understand the operation of law. I understand how it works. I have litigated hundreds of cases. So based on my expertise, they say, how did you learn how to win appeals in an appellate court? Because I have done this over and over and over again. I understand the operation of law. This took me years of experience and practice.
He put down, he understands the operation of law.
I just put it there.
That should be writing it down. He understands it's not magic. He ain't throw stones up in the air and put his hand together and say a prayer. He's just do study. So he's giving us his years of study and experience. So not just years of study, it's years of study and experience that he's bringing to us. We need this. We need this. The questions are great. There's no such thing as a stupid question, because the questions are based on a lot of misconceptions and a lack of study. Questions are based on misconceptions and lack of study. That's why we're here. That's why we have this committee, but we know we needed to do classes first. There's no need to give assignments out. That's a waste of time. Because then what happens is that we're going to end up having to come back to do this anyway, because y'all going to have 1,000 questions. So to alleviate 1,000 questions, we do 2 to 3 months of classes. We'll determine after 2 months if we need to go another month of classes. so that you'll be grounded in fundamentals. So that when we give assignments out, you have the fundamentals. And then we also have the recordings. Please listen to the recordings, take notes, listen to recording 2 or 3 times. Take notes, slow it down. He's dropping jewels. When I said to King about 4 months ago, and this is when I knew he was going to be coming to the conference. And I said, King, he'll tell you. I said, King, when I see you, I'm gonna give you a big hug. King, what did I do when I saw you?
You gave me a big hug.
Yep. I sure did.
You
All right,
gave me a big
continue.
hug.
Kang, can I ask you one more question?
Yeah.
Can frivolous, can that be used interchangeably in a court of law?
Can what?
Frivolous. When a judge say that your claim is frivolous.
I don't understand the question.
Okay.
He's saying frivolous, King, he's saying frivolous. F-R-I.
I know what frivolous is, but I'm trying to
I got
understand. And you need to put it in the context of a question that I can answer.
Because you had spoken before that if you don't present enough evidence, they can say that you're based in this or this accusation or claim or an account or situation on frivolousness. And I was asking you, can it be utilized in duality?
Still don't understand what you mean
by
by
there's been claims like cases, particularly conscious Moorish cases, have been deemed as frivolous by the court.
Right.
That's what he's coming from. That's the basis of his question, based on his talking to other conscious Moors whose cases have been thrown out based on that they were frivolous claims. They actually used the word frivolous. That's where he's coming from, King.
Right, and I was saying, because you was pointing on that before you got to this point. That's what I meant.
Yes,
right. But he said in duality. When he said
duality. Well, you know what? Don't worry about duality, King. Just frivolous.
Okay, so when we talk about, so this is what I mean. Okay, let's say the teacher give you an assignment and give you an essay to write on gun violence. But you start talking about food. Talking about, you start off with gun violence, and then you start talking about how great food tastes. That is frivolous to the assignment. It has no material bearing. You're not supporting with the assignment in which the teacher gave you. When you come under an application of law, it gives you a specific language that you have to meet the context of what you're asking the court to do. And if it's off topic or off subject, then the court is gonna say they don't know what you asked. This is frivolous. It don't make sense.
Okay.
Do that make sense?
That was well answered.
If I can, hello. They still use the word frivolous as a means of plausible deniability as well.
Right. That's how I was taught also too, because they probably know that they don't really have jurisdiction, so they'll say that your argument is frivolous because they don't want to. They know they don't have jurisdiction.
So when we talk about plausible deniability, put it in the context of what they're saying. You must understand what they're saying. So the first lesson that you have to get from the court, if they say something, they must reference that to a statute or a code, or they must define it. Because if they don't, they're operating from a secret jurisdiction in which nobody understands. That's the first lesson in law. So, for example, I was helping a girl with a mortgage case. We'll give you a prime example. The judge kept saying, "Did you pay your bills? Did you pay?" She kept asking the judge, "What is you referencing Tell me the source of law in which you're referencing.
Mm-hmm.
He could. You don't know what I mean? She was like, we're not finna play that game. Tell me the source. If you're talking about the contract, within this contract, Your Honor, is you talking about the Uniform Commercial Codes? Give me the source. Is you talking about, is this in the United States Code? Show me. So he kept using the term bill and pay. And she kept saying the same thing over and over. Provide me the source. And when he could not provide the source, that was an error in law. Because laws are put into categories. There's category of laws. You can't put me under you can't put me under all the law at the same time. Because if I'm dealing in real estate law, I'm dealing with a particular thing. If I'm dealing with criminal law, I'm dealing with a particular thing. If I'm dealing in tort law and dealing with tort actions, then I'm dealing with injuries and certain things. Law is put into categories. So we must understand that law is very broad. So we must put things in categories, and when people talk to you, they must reference what they're talking to you from.
Yep.
They
Put it
can't
in
just
proper
come from
perspective.
anywhere. It has to be relatable to the topic, to the subject matter.
Okay.
They can't charge you with gun laws in a tax case. If we're dealing with violations of a tax law, they can't not say, well, okay, we're going to charge you with this and associated with that. No, it has to be relevant to the subject matter. Do that make sense to everyone? So when we throw terms around like plausible deniability, where is they coming from? What source? It has to be defined. Or it's an error in law. I don't know what you referencing.
This is good one, man, because this is questions are very good, and allows you to clarify, you know, because you're going with foundation. This is very good. This is needed. This is why we need the classes. All right, before we actually get into the committee, putting everybody into different subcommittees. All right, so
I have a question.
yeah, go ahead, William.
Yeah, if you can you express the difference, if there is a difference between an affidavit and a foreign affidavit?
And a what?
A foreign affidavit.
A foreign affidavit?
Probably he's talking about probably making an international claim or appeal.
So an affidavit is an affidavit. So it's based in the same principle. It's a form of witnessing that's been authenticated by some type of official who has the power and the duty to perform some type of notary power. Doesn't matter if it's domestic or foreign. That person has the power prescribed under a particular application of law to perform such exercise of power, known as an affidavit.
Yeah, he's giving a general principle. Foreign with just it's based on the status of the people. I mean, that's all. If you it's based on the status. Japanese is foreign to China. It's just based on the status. But affidavit, as far as the general principle, he cleared that up. I mean, foreign affidavit. I mean, there's no foreign affidavit. It would be based on the status of the people. Your status, based on your status. It's the status. It's not. Let me finish.
I brought that up.
William, let me finish. William, please. All right. It's the status that will determine if it's foreign or not. It's the status, not the affidavit. Not that you're putting it on the affidavit because you said foreign affidavit. You use foreign as an adjective to describe affidavit. It's the status. Let's put that. The status is of the person or natural person will determine whether it's foreign or not. There's no foreign affidavit. It's the status. Are you clear on what I'm saying? For before you ask your question, William, are you clear on what I said?
Yeah, I hear what you're saying, but I'm trying to
No,
introduce why I brought.
wait, no, William. I didn't ask you that you hear
Never
me.
mind.
What? No, brother, hear me out, brother. No, I'm not, brother. I'm not being sarcastic. So please, not, bro. It's not being sarcastic. I didn't ask you if you heard me. I asked you, do you understand what I've said? I'm not being smart. I'm not. I'm not being a smart aleck. I'm asking that you understand what I said.
Yes.
Right, so I needed to know that first. That's all. That's all. I'm not. You took it at my being smart aleck. I'm not being that. It's over here underneath. Go on the side. On this side. Right here. On this. Yes. All right. So you do understand what I've said. All right. So what's your question?
Okay, I introduced that because I read once that a foreign affidavit could not be denied. Like if you just put an affidavit, they can still reject it. But if you put foreign on it, they can't reject it. That's in the recorder's office and everything. So if you
All right.
stipulate foreign, it cannot be rejected.
All right. You have a Japanese, a Chinese in China. Just follow me. A Chinese citizen in China. He's a Chinese citizen in China. So the Chinese citizen in China puts foreign affidavit and submits that to the Chinese court. A Chinese citizen in China puts foreign affidavit and submits that to a Chinese court. What does that mean? A Chinese citizen in China submits put the word foreign affidavit at the top and submits that to Chinese courts. That's why I keep saying the status.
Foreign national?
No, hear me out. Listen to it. I'm saying it again. A Chinese citizen in China. A Chinese citizen in China puts at the top foreign application and submits that to the Chinese courts. Chinese citizen, hear me out, Chinese citizen in China, all right? Chinese courts. Chinese citizen in China, Chinese courts. And he puts foreign affidavit. Does it make that a foreign affidavit? A Chinese citizen in China submits it to a Chinese court.
No.
No, Chinese citizen in China is national.
He's national, so that's domestic.
A Chinese citizen, it's all right. All right, hear me out. National is all right. You would use, all right, Chinese national is the wrong term to use.
Yeah.
So I'm glad it's the wrong term.
The United States, he would be a Chinese.
Hear me out, because y'all using the wrong term.
Yeah, you don't have national standing to the land.
All right, they're using the wrong term.
Right, I agree.
A Chinese citizen in China would not be classified as a Chinese national.
Agreed.
A Chinese citizen in France would be classified as a Chinese national in France. But not a Chinese citizen in China would not be classified as a Chinese national. The Chinese government will not classify her citizens in China as Chinese nationals. The Chinese citizens. Chinese citizens in Japan, France, England, Germany, South Africa are classified as Chinese nationals. But not a Chinese citizen in China is not classified as Chinese national. They're Chinese citizens.
So we're only Moorish nationals outside
Yes.
of our land.
Outside of no. Because
Yeah,
no, not land. Hear me out. So no. Let me explain why no.
Okay.
Because of Spanish, French, because of Spanish, French, Dutch, English, French colonization and conquest. The French, English, Spanish, Dutch, Portuguese, through conquest and colonization, created French zones through the Louisiana Territory, named after King Louis XIV, is a French zone. United States became the fiduciary trustee through the Louisiana Purchase because of that. So, meaning if you're in the jurisdiction of Morocco on your land, operating within the jurisdiction of Morocco on your land. But if you're operating within the jurisdiction of the occupying sovereigns, Spain, France, England, etc. You understand that? We got our situation is different, bro. Our situation is different because of conquest and colonization. So there's zones, French zones, Spanish zones. You understand?
Will we be nationals in those zones, or because those zones are theirs only through colonization,
at your job,
they will still be our land?
At your job, you're Moorish national. At your job.
Under the jurisdiction of a foreign nation, yeah.
Yeah, at your job, because those are foreign. Those are all companies and corporations that are established by, under states jurisdictions that are member states of the United States. Right. So at your job, you're a Moorish national at your job. So let me just use that example. Let's stay with that example. That's the clearest cut example that I can give. At your job, because your jobs, all right, are part of the member states, were licensed and registered under the member states that are based members of the State of the Union of the United States. So your job, you're a foreign national at your job. You're a Moorish national at your job. But operating in Moorish government, you're not. Operating in Moorish government, domestically, as far as jurisdictional wise, under Moorish sovereignty, operating in Moorish government, you wouldn't be a Moorish national.
Is then when you would be a citizen?
Yep.
Yes.
Awesome.
So by the court not being a creature of Article 3, wouldn't that make all our affidavits in that quasi court?
No, we're not a creature of Article 3. Hear me out. I sent out extraterritorial. Let's go to the treaty. All right. So that you don't never have to say Abdullah said anything. You don't have to never say that. Let's go to the treaties, Moorish treaties. You have to show me what you just said, William. You have to show me that in the treaty. What you just said, you have to show me that in the treaties. Not no United States Constitution. Don't show me no United States Constitution. What you just said, William, you have to show me the treaty. A Moorish treaty with the United States. You have to show me that what you just said in the treaty between the United States and Morocco, what you just said. Not United States, no, not United States statute, not United States codes, not United States Constitution. Because if Morocco and we did not delegate that authority to the United States
courts, Article 3. All right, Howenstein versus Lynham. All right, let me do this again. Howenstein versus Lynham. Ware versus Hilton. Ware versus Hilton, 1796. Society versus New Haven, 1823. Howenstein versus Lynham, 1879. Those cases, and two of those cases, Society versus New Haven, 1823, on Ware versus Hilton's 1796, are based in what? Adjudicated based in the 1783 definitive peace treaty between Great Britain and the United States. All right. The reason why United States Supreme Court have the authority to hear all those three cases is because there's no extraterritoriality clause in the 1783 definitive peace treaty between Great Britain and the United States. There's no extraterritoriality clause in between in the 1850 treaty between the Swiss Confederation and the United States. That's why you got to go to the treaty, not United States Constitution, United States laws. The United States, the treaty, the 1796 treaty between the Bay of Tripoli and the United States delegates that extraterritoriality authority to the Dey of Tripoli. The treaty between the Dey of Algiers and the United States, 1797, delegates extraterritoriality authority to the Dey of Algiers. The treaty between the United States, 1787 treaty between the United States and Morocco, delegates that authority, extraterritoriality authority to a Moorish consul. 1856 treaty between the general treaty between Morocco and Great Britain delegates that authority to the Moorish government. You got to go to the treaty. So whatever you say, William, you have to show me in the treaty.
So I want you to also think about this. When he's saying these treaties, these are application of law. He's referencing where he's coming from to show legal standing. And then he take case law from an international that support his which is a memorandum of law. And then you show the affidavit by Abdullah Bey, in which then support that finding of facts with other exhibits or documents that support his claim. Do that make sense?
Yes.
So Brother Carr here, that makes perfect sense. So in other words, if he didn't back that up with the treaties and all the evidence, that would be frivolous.
Frivolous.
There we go.
Null and void. That's right. That's right.
Now you see how it comes back around, y'all?
Beautiful.
King, you're doing it, brother. I love you, brother. Well, when I see you again, I'm gonna give you another big hug. I love this brother, man, because we need this, man. And I we need this. We need, because we come with misconceptions. And our questions and comments are based on misconceptions. So come with the questions and comments. This is great. We got 30 minutes, King.
Okay.
You'll continue. I did send both files to your email. I sent to Mia Moore and Ray. Brother William has it, and Mia Moore has it on your end. So, all right. I sent it out to everybody else. Yes. But William has it.
Check their email and their email.
Yes. There's two files.
Yes, it's
All
two
right,
files. And also,
so you're going to study that. You're going to study the two files along with this recording. When this recording is being released, you're going to study this recording and the two files. All right, we may not be able to get to the second one. It's about 5 pages long, but we'll do that the next third session. I continue, King.
And I want y'all to remember how Abdullah was going to the treaties in the application, but one component that you must serve the application in the venue that's allowed to hear it. Every venue is not allowed to hear every topic. A venue is a particular assignment to hear particular matters. So even if you have the proper affidavits and application, if you present it in the wrong venue, it's going to be mute because they can't hear it. So you must go to the proper venue after you get all of your application and everything together with supporting affidavits and your exhibits showing the findings of fact, so the court can make a conclusion in law. You still must put it in the proper venue. And the United States courts is improper venue. This is why they say it's frivolous, because it's mute. We can't even hear it. You're not in the proper venue. We can't even discuss this. So you making what they call as a mute point. I hope y'all getting this.
Yes, loud and clear.
So when you understand how to do this, everything start making sense. Now you go down the checklist. Did I make sure I'm in the proper venue? Am I on point with the subject matter? Did I have the supporting affidavits and the exhibits to support my claim? Did I make sure that the court can come to a conclusion based off what I presented? Brother William, do that make sense?
Yes, it does.
It does.
My only thing is, like Brother Abdullah was saying, that the Article 3 courts was delegated through the treaty, but the Article 1 legislative courts that these administrative tribunals are not delegated by those treaties. So that was my point right there. That everything that we do and address in an administrative tribunal would be foreign.
No, all right, let's go once again, William. Just got to show me that in the treaty. All right, we're gonna make this simple. All right, we're gonna kiss this. What you just said, William, you have to show me in the treaty, not United States statute. Don't send me no United States statute, no United States codes. Show me in the Moorish treaty what you just said. I hear what you're saying, William, but just show me in the treaty. That's all. What you just said.
Yeah.
Let's show me in the.
That's what I'm saying. To my understanding, it's non-existent.
No, I'm saying. So therefore, if it's not in the treaty, if what you just said is not in the treaty, what point are you making then? If it's not in the treaty, with the statement about Article 1 administrative court, if it's not in the Moorish treaty, it doesn't have standing. It's not in the Moorish treaty. Hear me out, brothers and sisters. I know this is going to take some time. I understand this. Please, I understand. I got 25 years of misconceptions. So I understand, because myself, and I was part of that, of pushing the United States Constitution. I was part of that. So I understand. But once we have to grow strong in international law and treaty studies, you have to go to the treaty. The operational law. So King, I want you to speak on the operational law regarding Moorish treaties.
Okay. So when we're dealing with the operation of law, when you're dealing with treaties, as it relates to venue, I want y'all to keep this in mind. Venue is where an institution has the power through assignment to deal in particular subject matter.
You heard me?
I need y'all to understand that. If the treaty doesn't convey, assign, or allow such institutions by
Mute
its
your devices,
operation,
please. Mute your device, please.
by its operation under its authority, then it is inadmissible and cannot be heard, which you would never have standing based on the subject matter you are trying to present in that court. Because it doesn't, by operation of law, give the authority or assignment to exercise such power. Treaty power, dealing with a treaty application. So you are exercising a power not granted by treaty, making it an improper venue. One of the things in treaty, in operation of law, you must think proper.
I have a question.
You don't get to do what you want to do. This is why they have treaty. Treaty is a contract. By its own assignment under the operation of law, based in treaty rights. If the treaty doesn't have it clear, the treaty should outline who has the authority to exercise the power and what venue. If it wasn't assigned to the United States, Article 1, Court, Article 3, by treaty, then it's inadmissible, inoperational, it cannot be heard, and it's a mute issue. It's frivolous. I hope I made
So
that.
the question would be, what about when they're the ones that's doing it? That's what I'm saying. They're the ones that implement delegations of authority that never came from the treaty.
They're all fraudulent. They get away with a lot of fraudulent things that's going on. So another thing that I found out is that you can't mix oil and water. It's kind of like the Matrix. So you can't be using administration paperwork and stating, hey, I'm a Moroccan national using Moroccan laws, but yet you're trying to use paperwork or documents to have them hear you out in the U.S. Constitution or being up under the U.S. because we were all adopted by the U.S. So if you're still adopted by the U.S. and you haven't corrected your status, but yet you're filing all these documents saying, hey, hear me out, hear me out, hear me out, but you haven't corrected your status yet and taken yourself out of their jurisdiction, to them, you're still, in the eyes of the law, dead.
Okay, so let me ask you this before you move any further. When you say correction of status, show me in treaty or in code what you reference.
Nationality instead of being black.
No. Show me by treaty. Show me the reference point in which you relying on, the source of law. We talking about application.
United Nations Declaration on Rights of Indigenous People, or you can go to Article Human Rights, say everybody have a right to a nationality.
Right.
So you relying on an application based on, and where's the venue for that assignment? If you're relying on that application, where's the venue you supposed to present such argument?
The ICJ.
Okay. Do it say that in that Is it in that compact? Is it in that? I want to know where do you go? Who
Council
prescribes?
courts.
Hold on, wait a minute. Who prescribed such treaty, compact, or what is that? Convention. Who prescribed it? So we can determine who has the authority to exercise the power of hearing and granting such application.
Putting people on notice, publishing.
No. That ain't what I'm asking. This is what I'm saying. We must understand.
Is it council court? Because that's who have authority to hear nationality for the Moors is our council courts through our government structure.
Okay, so where's the Moorish court at?
We are yet to establish it. That's what.
Okay, so where else will we have the right to go exercise when we talk about right of nationality based on the application y'all presented? Y'all presented it, so you should know where to go to make such an argument.
8 or 10 hours in case you on what the temperature danger zone. Here's a quick picture.
I'm asking y'all. You bring up a topic, you must know where to go to be able to present the subject matter to make such argument based on the venue who is allowed to hear and come to the findings of fact and conclusion of law based on what you just stated. Who is allowed to entertain it?
United Nations.
Causes high temperature. Cooked to the raw
United Nations.
United Nations is a membership.
Well, I'm saying council court.
No.
ICJ.
We don't have a council of court yet. What other venue is we allowed to entertain? I'm asking y'all.
The ICJ.
Are you sure?
International Court of Justice.
Yes, International Court of Justice, hear human rights cases.
Okay. So you are in the wrong venue. Go to the proper venue and make that claim. In proper venue. You can't come in the United States. Go where the application is assigned where you can hear such matter. This is what I'm trying to tell y'all. We are all over the place because we don't understand operation of law.
Abdullah, I got a question for you, brother.
Okay.
From my understanding, are there two factions of Moors? Is there Moors and Moorish Americans? Because I know Noble Drew Ali was very big on us proclaiming and declaring our nationality, but there was never no set process.
All right.
For that to be done.
All right. There is a set process. One, let me first address your first statement. Let me address your first statement.
Uh-huh.
All right. A question. Are there different fashions of Moors? No. Hear me out. Let me explain.
Okay.
So I mean, like, Moor is our nationality, which denotes our ancestry.
Historical, right?
I'm talking genealogically.
Oh, genealogically.
I'm talking genealogically.
Okay.
Consanguinity, descent, ancestry, lineage, pedigree. There's no different faction. All right. There's no different blood, all right, of consanguinity. There's no different ancestry, pedigree, descent, national origin. We're all the same pedigree, ancestry-wise. What you're asking about, there's different levels of consciousness, not different fashions. Let's put the proper word.
Right.
The proper word is different levels of understanding, different levels of knowing. The word conscious, S-C-I, the root word is S-C-I, as in the word science. It means know. So there's different levels of knowing, not different fashions.
No, the reason why I say Abdul is because, and this probably is a misconcept. I've always heard people say that there's a difference between us being Moors and them being Moorish Americans.
All right.
Because they say
No.
Ali called us Moorish Americans, and Moors is of historical.
All right. Hear me out again, but it's based. All right. Once you understand what it's based in, though, brother.
Okay.
Consanguinity.
Bloodline.
Genealogy.
Right.
Right. Write these down, please. Please write these down. Please.
Okay. Bloodline. Go ahead.
And I want your everybody's assignment is to look these words up. I want you to draw a circle. Everybody draw a circle. And not on a sheet of paper in your notebook.
Okay, go ahead.
Put the word nationality in the circle.
In the middle?
In the middle. Put the word nationality in the middle in the circle. Shooting out of that, you're going to have lines shooting out of that circle, connecting to that circle. You're going to have genealogy. Ancestry.
Okay. Ancestry. Okay.
Consanguinity.
Consanguinity.
National origin.
National origin.
Descent.
Descent.
Pedigree.
Pedigree.
Did I have ancestry? Did I have ancestry?
Yeah, you said that already, yeah.
I said that already.
Yeah.
Parentage. Lineage.
Hold on.
Yeah, lineage. All right?
Okay.
So once you understand, once you have a foundation of the consanguinity aspect of nationality, then you would know that there's no different fashions. It's just different levels of knowing.
Okay, so once we have the understanding of these different terms, how do we make proof claims of these terms that we come through all these terms?
All right. One, it's raising our level of understanding, brother, our level of knowing. We've been, Jim and I, for the past 5+ years, have been addressing misconceptions. We've been successful because y'all here.
But you're not connected to everybody who is referred to as a Moor, as any dark-skinned person. They can't say you're not. You would never refer to anybody in your family as historical. They just your family. I'm just a Moor.
No, but what I'm saying is, are we talking about as far as the beginning of civilization or the beginning of? Are we talking about from the beginning?
All right, let me out. What I'm talking about is
most people would say Moors is not a term that started in the beginning.
All right, but you asking me? Habil, you asking me the question?
Yes, I am. Go ahead.
You're asking me, not Yeah. So you ask. So what I'm talking about is consanguinity. That's what I'm talking about, consanguinity. I'm not what other Moors doing. I'm talking about what I'm talking about. Consanguinity. That is powerful. That knowledge base of knowing that we are all of one mother that has given us suck. That's consanguinity, genealogy, lineage, ancestry, pedigree, descent, national origin. The 1935 German Nationality Act. In the 1935 German Nationality Act, German is used in a consanguinity sense. Prior to that, it had been used in a political sense. So German was no longer being used in a political sense. It's being used in a consanguinity sense. So I'm talking about the consanguinity sense of nationality. That is our starting point, because you're talking blood rights, inheritance. Inheritance claims is based in consanguinity.
And that comes through the woman, right?
Yes. In my book, Moors and Masonry Part 2, in Moors and Masonry Part 2, Chapter 2, Moors and Masonry Part 2, Chapter 2, I have, in explaining the consanguinity sense of nationality, I have a picture of a woman with a child fetus in the womb. And you see the placenta, the umbilical cord. That's nationality right there. I'm showing you a picture. I show you a picture of tying nationality to that genetic biological process. On the right side, I show a scroll. That's citizenship. That's political. Nationality is tied to a biological. So nationality is not acquired. It's inherited.
Oh,
in international law. Just hear me out, because this
Glad you
because of
cleared that up.
misconceptions. But I'm there, but I understand you. Trust me, I understand where you're going. This is for everybody. In international law, when you look this up, look up the acquisition of nationality. The acquisition that's in international law. This is colorable. That's a construction. What makes it a construction, Abdullah? Acquisition. See, you gotta understand language. Acquisition of nationality is constructed because nationality is not acquired. It's inherited. You can acquire a car and also inherit a car too, but you cannot acquire nationality. Nationality comes about through what? A biological process of you spending 9 months in your mother's womb. It's a genetic and biological process. So when you think of nationality, so when the word nationality comes to your mind, whenever you say the word nationality, an image of a woman and the fetus connected to the umbilical cord and placenta, that should come to your mind. Nationality, woman, pregnant woman, fetus, in the woman, 9 months. I show a picture of that. What they've done in international law was give a distorted meaning, get us away from that understanding of nationality. So nationality, you cannot change your nationality. So the Article 15, Section 2 of the United Nations Human Rights Proclamation is a constructed fraud. You're going to have a right to change your nationality. I know what it reads. Why? Why don't you have a right to change your nationality, Abdullah? It's impossible. But you want to change your blood? See that? See what they done? Well, so they suppressed the consanguinity sense of nationality.
Oh, okay.
Right. It's the language, the basic tool for the manipulation of reality is the manipulation of words. Those who control the meaning of words control the people who must use them. Yeah. See, Article 15, Section 2 of the United Nations Human Rights Proclamation reads, everyone has a right to change his nationality. So now they set a constructed meaning there. So you're thinking that nationality is political, comes about through a political process. No, nationality comes about through a genetic and biological process. They're constructing, they're stealing, they're maintaining European conquest, subjugation, through language, not language, through constructive language, not language, through constructive language, are moving away from the original application, the original concept and intent. So the original application, concept, intent of nationality is that it is biological and genetic process.
Okay, so Brother Abdullah, do we proclaim it and declare it by way of a governmental nation?
Structure, through government, Moorish government structure, through Moorish, not
through a Moorish government,
through Moorish government structure.
Government structure, okay.
But we got to clear off our concepts, though, and that's what yes. So that's why it's important for us, before we break y'all up into subcommittees and give y'all any assignments. And King and I have talked at great length about this. We got to educate y'all. All right, let's imagine. Let's walk with me. 3 weeks ago, we broke y'all off into subcommittees. 3 weeks ago, we broke y'all off to subcommittees. We didn't do no lessons. We didn't do any lessons. We broke y'all off in subcommittees and gave y'all assignments. Y'all would have 1,000 questions right now. Remember, this is the second meeting. Remember, so let's imagine we broke y'all off in the subcommittees and gave y'all assignments for the day. Y'all would be lost. This is why we have to have education.
I'm all for it.
All right. So we're going to end here. No more questions right now, because we're going to end on time. All right. So we got 4 minutes, and we're just going to everyone has the two files. So study the one that King went over today, and the one that we didn't get a chance to go over today, and we'll do that next time. And also when this video is available, the recording is available, I'll send it out. All right. So it's to review today's class and also the two files. And we'll have that second one, that 5-page for next session. King, you want to have any last words, King?
Yeah, it's very important to pick up where Abdullah is saying with language under nationality. It's very important because, and we must understand all of these things in which I'm conveying to you guys about venue, right? Being able to make the proper argument based on the particulars in the subject matter, what you're trying to make a claim about. A lot of us are raising issues in improper venue is deemed as frivolous. We are not understanding we're taking a argument which was assigned to a particular court, and we're trying to make other courts hear such subject matter in which they don't have the authority to do. We must understand how to bring this all together. It's very important that you listen and come to these classes, not just mine. Brother Kono got a class. Y'all got to come to these classes. Brother Quasi, he teaching. We got to come to these classes. Take notes with pen and paper. You're not going to get nowhere half-assing in studies. This is why we are lost today. We must take this serious. You must come to these classes. They're free. You're not getting no better information. Abdullah is so articulate in treaty. Him and Shem are particular in treaties. They are masters in treaty law.
Interjection on that. Can we being that I'm new, can we put these classes in the chat so that I can go ahead and have them for all the study sessions, if you don't mind?
They're on the Moroccan Post School Media, the Moroccan Post Media YouTube page.
Okay.
Moroccan Post. Somebody put in the chat, please. Somebody put the link in the chat.
Please.
Man, let's go put the link in the chat. Just go to that link that sends you to the Moroccan Post Media YouTube page. I mean, that's it's gonna be in the chat. No problem. Now this is a private. This is private now. You're not. This is not to be shared. To what we did, the first one. These committee sessions are not to be shared.
Okay.
Right. So they're gonna be Sister Mia Moore will get it, and then she'll furnish it to on your end, and I'll send it out on my end. Right. So these are not to be shared. This is private. Mean that when you get this link here for this recording, it'll take you to the YouTube page, but that's private. It'll go to the Moroccan Post Media YouTube page. You click this link for this recording. All right. But it's private though. Terrence set it for private. So even though it's on the Moroccan Post Media YouTube page, but he set it for private. It can't be viewed by other people.
Thank you, Amanda, also for sending it.
All right. So until next time, this was when we have I think it's every first and third what? First and third Saturday, 3:00 p.m. Eastern Standard Time. This was just we didn't have class last week because I had to do I did a lecture in Somerset, New Jersey to Masons. That was scheduled 10 months ago. It had been scheduled 10 months ago. So I wanted to have it today, and King and I put a lot of time in preparing the lessons for today. All right, so we're going to end. All right. So the first first Saturday. See y'all the first Saturday at 3 p.m. Eastern Standard Time. When's the first Saturday? Is that next week? Please don't say next week.
I think
Yes.
next week.
Oh,
it is next week.
It is next week.
I'm excited. We're not canceling class, are we?
Hey King, what do you want to do, King? We ready.
Islam, I thought it was the second Saturday and fourth Saturdays.
Yeah, I think it is the second Saturday.
Yeah, it's the second Saturday and fourth Saturdays.
Thank you. I was wrong. Thank you. Second and fourth Saturday. So we got good. But we're ready. It's like we already have the file. So we'll see y'all in 2 weeks. Second Saturday, second and fourth Saturday of the month, 3 p.m. Eastern Standard Time. Thank you. Whew.
That should be the 12th.
Give me another. I can at least because I've been on it, man. I'm worn out,
We'll
man.
see each other on the 13th then.
Yes, on the 13th. Thank you for the date. All right, see you on the 13th. Peace, everyone.
Peace, everyone.
Hit the recording. Hit recording. Must stop. Put the stop with the recording.
Peace and love. Much gratitude for class today.
Gratitude.
Wonderful class.